So let's get into it. First of all, thank you guys so much for all the sweet messages you sent me after yesterday's episode where I was...
In a stunning turn of events within the ever-deepening legal and PR drama involving Blake Lively and Ryan Reynolds, a fresh spotlight has been cast upon their tactical maneuvering in court. Strategies that many now view as calculated attempts to shift focus away from more troubling developments. Katie from Without a Crystal Ball has dissected these developments, offering insights into how the celebrity power couple seems to deal with crises. Not by addressing them directly, but by flooding the court docket with dense, overwhelming filings. According to her, when Blake and Ryan need to exit a PR catastrophe quietly, they launch a barrage of legal documents that are highly performative, designed to control the narrative while putting legal pressure on others. They blame Wayfair for alleged non-compliance with discovery procedures, attaching over 4,000 documents to support their claims. Simultaneously, they file motions for sanctions against opposing counsel and issue subpoenas to various content creators, only to turn around later and tell the court that all these issues have somehow magically resolved themselves. These tactics, she argues, are the ultimate bait and switch. A distraction meant to generate noise in the courtroom and on the internet while quietly sweeping problematic elements under the rug. Perhaps most telling is how, buried deep at the bottom of one of their letters to the court, they casually request that all motions for sanctions simply be dismissed. An astonishing ask considering the aggressive posturing they took just days earlier. Imagine if the roles were reversed. If Wayfair had been the one to sneak such a request in a footnote at the end of a lengthy filing, one can only imagine how Blake's legal team would have reacted. They would likely erupt, accusing Wayfair of undermining the court and failing to take the legal process seriously. The hypocrisy is palpable. This footnote, barely visible unless you're combing the document line by line, declares that Blake's team believes all outstanding motions from social media personalities like Lynette, Popcorn Planet, Swifty Forever, and Pop Diaries are now moot. Essentially, they want all subpoenas quashed without further discussion. The court is being asked to brush aside the legal rights of these individuals, creators who have been subpoenaed, some of whom are asking for anonymity, sanctions, or protective orders. Blake's legal team is signaling they won't even bother responding to these motions, and instead want them tossed out purely on procedural grounds. But there's a glaring issue with that. Not all concerns have been resolved. Katie emphasizes that this approach isn't a legitimate or responsible way to deal with motions for sanctions. It's not just informal. It borders on dismissive and some might argue reckless. Even more interesting is who Blake's team didn't mention: Perez Hilton. Despite being central to earlier claims, Perez isn't addressed at all in this new letter. Could that be because the case against him isn't as easily brushed aside? And what about the subpoenas issued to Google, TikTok, and X, formerly Twitter? What data did those companies hand over? Were any legal protections breached in doing so? Because if the subpoenas are overly broad or lack merit for even one creator, then logically, they should be problematic across the board. Blake's team appears to ignore that reality, pretending their reach and requests are inherently justified and beyond challenge. Their tone essentially: don't question this. Just move on. The timing of these maneuvers is notable too. After spending the previous week aggressively targeting the internet and its content creators, Blake's PR machine now seems intent on reversing the narrative, accusing Wayfair of dragging its feet in discovery and portraying attorney Brian Friedman as some sort of relentless villain trying to assassinate her character. Katie sees all of this as little more than a smokescreen, a calculated media strategy designed to draw attention away from the damage control needed after their own missteps. And when you dig into the details of their complaints, some of it feels oddly petty. For instance, Blake and Ryan are reportedly upset that certain discovery items haven't been produced, items that may not even exist. In Katie's view, their inability to accept no for an answer is central to this issue. She notes that Blake has openly admitted she hates being told no, and Ryan isn't much different. So when Wayfair responds with, "We don't have what you're asking for," Blake's team reacts not with understanding, but outrage. Perhaps the most absurd example of this outrage, Katie argues, is Blake's exasperation over not receiving communications from Jen Ael, a former PR associate, during a specific promotional window. She insists something must be wrong. How could these documents not exist? But here's the kicker. Jen Ayel doesn't have her old phone anymore. She doesn't have access to her previous email account at JonesWorks. She doesn't even use the same phone number. And why doesn't she have that phone? Because Blake's own team took it. That's right, Blake's legal team acquired the phone via a sham subpoena and had it handed over through Stephanie Jones. They extracted its contents and then acted surprised when documents from that very phone couldn't be produced later. The irony is staggering. And yet, Blake's team has the audacity to claim the discovery process isn't being honored by Wayfair? It doesn't stop there. They also accuse Wayfair of failing to comply with Electronic Stored Information, ESI, protocols, specifically, the provision of metadata. But this accusation rings hollow when you realize that Blake's team submitted an entire file from Stephanie Jones, taken during the Vanson lawsuit, which lacked metadata entirely. They admitted that it didn't follow protocol, and even acknowledged that some of the documents might have been altered. Yet, they still included them in filings, using them as evidence. So what are we doing here, really? Katie points out that among these documents is a particularly shady-looking text message thread allegedly sent by Melissa Nathan to Jennifer Ael, dated August 6. This message, which Blake's team claims they never received, contains a quote for social media reputation management services that promise to be untraceable. That's right, untraceable. The quote outlined a campaign costing $175,000 over 3 to 4 months that would include Reddit and social media takedowns, crisis response strategy, and starting social theory threads to misdirect audiences. The text explicitly states that the intention was to control the narrative without it being traceable back to the source. How convenient. And yet, Wayfair never included this text in their discovery disclosures. It wasn't part of their timeline, and it wasn't brought up in any of their arguments. Why? Blake's team is alleging this quote exists but hasn't produced it officially either, raising questions about whether they're trying to cherry-pick what gets submitted, or whether they're playing games with what's considered admissible evidence. If they do have this damning message, why hasn't it been formally submitted as evidence? There's another strange detail. The message opens with "Hi Jamie and Jen," but Jamie isn't actually copied in the thread. That's suspicious on its own. And within the text, Melissa Nathan praises the PR results and lays out how two social media can scrub content, start discussion threads, and spin the crisis in a way that protects Blake Lively's image. This isn't just about proactive branding, it's about covert manipulation. One part of the quote even states that for $25,000 per month, the team would go back and forth with negative accounts, essentially engaging in digital warfare under the guise of PR. The campaign was clearly intended to insulate Blake from fallout related to her film release and the larger controversy at hand, and it extended beyond Blake to cover all involved parties. But again, despite its relevance, the quote hasn't been fully documented by either side. Why? Katie believes this entire episode reflects a deeper truth. Blake's team isn't just managing a legal case, they're managing a PR war. Every filing, every letter, every motion is as much about headlines as it is about legal substance. They're creating a narrative that positions Blake as a misunderstood figure, someone being unfairly targeted and attacked by trolls, rogue lawyers, and heartless corporations. Meanwhile, they are deploying tactics that mirror the very behavior they accuse others of. Whether it's claiming data wasn't turned over when it was, pretending not to know why documents are missing, or quietly asking courts to dismiss arguments they once claimed were critical. It's all part of a broader strategy. A strategy built not on transparency, but on obfuscation. And in the end, one has to ask, what's really going on here? If this case is about accountability, then why is so much effort being made to obscure the facts? Why are critical communications being left out of official filings? Why are creators being subpoenaed, only for those subpoenas to be withdrawn without explanation? Why is there such resistance to discovery compliance, and yet such eagerness to accuse others of the same? Katie's assessment is clear. This isn't about justice. It's about image control. And the deeper you dig, the more it appears that Blake Lively and her team are less interested in resolving the truth, and more focused on ensuring the public only sees what they want them to see. Whether that's through quietly dropped motions, sham subpoenas, or untraceable PR campaigns, The playbook is all too familiar. It's not about who's right, it's about who looks